Hello, it's Philip Taylor speaking from Richmond Green Chambers in London, and this morning on this beautiful hot day, and it's very hot as you can see because I'm sweating a bit, nearly 100 degrees the temperature today. I'm looking at a book from Edward Elgar, first class publishers. It's only a short review, this one. It's called Executory Contracts in Insolvency Law, this book here. It's a global guide. It's been edited by two people, Chuah and Eugenio Vaccari, and it's part of the Edward Elgar Publishing company's Elgar Comparative guides. They're important works. They're works of reference. They are helpful to both practitioners such as myself as a barrister at law and a mediator, and they're also very helpful, I think, for the academic community. I've given the title of our review An Invaluable Legal Tool for Practitioners on Cross-Border Perspectives Covering Insolvency Law. Now, there's a lot in that. We're looking at cross-border perspectives, that's international boundaries, and how we deal with the issues of insolvency law concerning executory contracts. And that in itself is a major problem, because I've taught contract, the law of contract itself, and I do know many students have difficulties with some aspects. Bearing in mind that I do believe that treaty on contracts, which is the statement on the law of contract, is incredibly important. But we're interacting here with both contracts and, of course, the law of insolvency itself, which is equally both emotive and actually not as easy as people would think to understand. We have the insolvency rules, we have all sorts of ways of dealing with the problem of insolvency, because putting it bluntly as a practitioner, quite a lot of people I come across who become insolvent are crooks. No doubt about that. And you've got to therefore realise they're not criminals in the sense of the criminal law jurisdiction, but they're certainly flying very close to the wind at the expense of many other people. And I say that as a person, like many I'm sure, who has actually had bad debts which you've had to write off because of the behaviour of people who've done despicable things. And it's happened to me, and it'll happen to other people. Let me first of all though have a look at the book itself. It's a hardback, and it's a detailed book from Elgar. Elgar produced very, very good books. There's the, I'm not telling you on its side, there's this case on the front there, that's the spine. Then at the back you can see the information, and of course Chuah is Professor of Maritime Law and Head of Department in the City Law School at City University of London. That's the old City University, of course. And Eugenio Vaccari is Lecturer in Law at the University of Essex. There's the book itself. The back of the book, you can see, runs to 700 pages. The index is by paragraph numbering, and you can see it runs through. There's quite a lot. All the usual suspects are in the index. You can see that it says, note, the abbreviations ECs refers to executory contracts. So that makes it hopefully a little easier. You can see even at the back the paragraph numbering and the footnoting. If we go to the front, very much the house style for much of the work that Elgar produced. They do produce really good quality publications for us. We have in the past reviewed a lot of the academic stuff. We do practitioner stuff mainly now. There's the detail of the book there, and then you've got the content section split into various parts. The civil law system, part 1, part 2, common law legal systems, and part 3, hybrid law systems, and looking at different jurisdictions: Canada, Cyprus, India, or South Africa, and United Arab Emirates. Then you've got extended contents. Remember one thing today, we're talking about insolvency law, and we're talking about cross-border, so we are talking about the global perspective all the way through. So you've got the extended content section there, and there's a lot of detail. You should be able, by looking at the extended content section and what you've got at the back in the index, you should find things pretty quickly. The list of editors, we've got the two editors who I've mentioned. There are a lot of contributors. I can't go through them individually, but I'd like to thank them all very much indeed for the huge amount of work that's gone into this. We don't review books which we consider to be not very good. There's no point, because it hurts the author, and at the end of the day we only try to review books which we think will be relevant to us in the practitioner and academic world. Chapter 1, you can see the structure. You've got a nice little contents section, which I think is always very helpful for the little index for the beginning of the chapter. Then you've got the paragraph numbering. There's no footnoting on that side, but this next page has a bit of footnoting. Then it runs through and it sets out how you do it. Here we go, chapter 3 again, same sort of structure, and it runs all the way through. It's a heavy book, very much an international flavour to it when you read the individual chapters. Let's hope that stands up there. As I say, this is a short review on this occasion, and what I say is this. It's a superb work which offers a unique, comprehensive and up-to-date transnational study of the topic, including an analysis of certain countries which have never previously been undertaken in the English language. And I think that's a useful step forward for us, because we have to recognise the power of the global community today. It's been written by experts in the field. The contributors, a substantial number of people. They've got extensive experience of both research and professional experience, and it's basically a groundbreaking investigation into the philosophies and the rationales behind the different policy choices adopted and implemented by a range of over 30 jurisdictions across the globe, because we are moving, I think, much more quickly than we realised into this. It's called a global guide. It's the global workplace, if you like, where we are facing things which the law has never actually caught up with at all, and it's going to take a long time for legal systems to catch up. Remember the way the book is split up into the various parts, but we are looking at the moment in an urgent need for us to start seeking, where we can, international agreements in certain areas. I had hoped, as I think many people did, that we might, through membership of the European Union, have some bringing together, but clearly with what has happened with Brexit, that is not going to happen in that particular way. So we'll look at other ways of doing it. What the authors and editors have done is they brought together contributions from more than 40 experts. They're insolvency law experts, and they give us, as practitioners and academics, extensive coverage of executory contracts, encompassing both developed and developing countries. And these contracts, of course, are very important, and drawing on not only so-called common and civil law systems, that's parts 1 and 2, but also countries with hybrid systems of law. And I suppose to a certain extent, I don't think the Scots will like this, we could say we've got a hybrid system of law in the United Kingdom, because we've got Scottish law, which is different from the law of England and Wales, and we've got Northern Irish law, which is really English law, but it's got a few bits and pieces which are slightly different. And of course, that's even when you look at the development of the common law across the planet, and you think of America, you think of the Commonwealth jurisdictions, you can see that the common law itself has been topped and tailed to suit the people in those countries. I'm thinking of Australia, I'm thinking of Canada. I've seen the Canadian system. It's based on what we've got. I've seen the American system based on what we've got, but it's suitable for their own requirements, and that's how it's going to develop, which is why I think this book is quite important, because we've got to look at insolvency law. It's a serious area of law. As I said, quite a few of my clients have not been quite the sort of people one would want to see. Some of them have been victims, clearly, but there are one or two people who play the system, and of course that in itself is a problem. Now, the title explores what this is described as ipso facto clauses. Improvements that could be made, as well as casting light on procedural and tactical issues and considerations when attempting to address executory contracts in the different jurisdictions. I think that's the greatest benefit for the practitioner and the academic. It provides a globalised and comparative perspective as well on executory contracts in insolvency law itself, and therefore I think the work will be an invaluable tool for legal practitioners who require a cross-border perspective on the subject matter, as well as, of course, for academics for their research and people pursuing the topic of study for a particular mission they have. I think it will also be of benefit to policymakers and institutions seeking to introduce insolvency law reforms in their home countries, because again that is, I think, is an important point to bear in mind, because it's the sharing of information. There are some countries where this is not going to happen, but one of the things about the development of the common law over the centuries has been the sharing of ideals. My view is well known from my lectures and everything else. We have the greatest system we've devised on earth, which is the common law system. It is the best. It's got its faults like everything else, but it works better than anything else, in my opinion. And obviously there are other people who take a very different view. But I'm glad that we have it, and I'm glad we've shared it with such a large number of countries. The book was first published as a hardback and as an ebook in 2019, and I'm recording this in the summer of 2019. Let's just have one last look at the book. There it is. There's the front, there's the spine, and then there's the back, hardback. It's a heavy book. I'm quite surprised at how heavy it is. Very nice paper it's been printed on as well. 700 odd pages. Let's just go. I'm just going to take one particular. This is Bangladesh. Now, what you've got here, you just see the structure. You've got the paragraph numbering, and you've got the footnoting, and then you've got concluding remarks, which basically comes out with each of the chapters. This one's chapter 26, of course, but the concluding remarks are quite helpful, because you therefore, again, you can see right at the end, this is India. You've got, again, the same thing. I think that will try to give the reader, that's the researcher, the practitioner, or anybody with an interest in this area, it will give them some idea of the direction that we're going. I'd like to thank Elgar very much for producing this work, and of course Jason and Eugenio very much indeed for the massive amount of work that's gone into this book. It's extremely helpful for all of us, and I found it very interesting. One of the greatest books I've always enjoyed reviewing is Chitty on Contracts. Insolvency law has always been of an interest to me because of the company law element, which I dealt with when I was reading law at university. But I do find this a very interesting work in its own right, and I'm very grateful to Elgar for sending it to me for review. Thank you to all. Bye-bye.